Let's go.
Well, good evening, everyone. It is Monday, November 10th. It is the 250th birthday, Kostas, of the United States Marine Corps. So happy birthday to our United States Marine Corps and Veterans Day Eve. So big thanks and big blessings to all of our veterans out there who are tuning in. Kostas, how you doing, man?
Good, and thanks, of course, for both of those reasons. Thanks for everyone who has served. I never served, so thank you for protecting my rights while I just laze around here. So,
amen to that. Did you ever think about serving?
Not realistically, because I had parents that were like, "No, you're going to go to college," and they like ingrained that into our heads. My dad did. He was conscripted and did Green Berets in Greece as part of the Greek army, and he because everyone serves there, and maybe that's a better system, but. He didn't want me to do it. I should have given it more thought in hindsight.
I started college at Washington State University with an ROTC scholarship, and then I kind of just burned out of it because it was cutting into, well, a lot more fun activities that I could have been doing when I was in college. And while I don't regret that, what I remember of it, I actually have some regrets about not having served, simply because I just think that it would have given me a different view of the world, a more worldly vision of things. I think maybe perhaps a little more empathy and compassion for things. Maybe I'm wrong. Maybe the vets can tell me that, but I do regret that. But I God bless all of you who did serve, and we can't thank you enough. Hey, you know who we got for our guest tonight?
Some YouTuber, I heard.
Yeah, some YouTuber. Actually, we got the 2A voice of the year, the top voice of the 2A, Mark W. Smith from Four Boxes Diner. He'll be here in a little bit. That's going to be pretty cool. And I will remind everyone that we're going to do our volume 3 of Behind Enemy Lines. That's going to be Monday, December 8th. So set the calendars now. Listen, I want a few things I want to go through with you before we bring Mark on here, and then we'll have a bunch of things to go through with him as well. We're in that time of the year where we got all sorts of petitions before the United States Supreme Court. We got a ton of them, and we got some big Fridays coming up soon. But one of them that is not scheduled for a conference yet, but I want to talk to you about it because I think you're familiar with an issue real similar to this with California Senate Bill 2, and that's the Schoenthal v. Raoul out of the 7th Circuit. That's a challenge to Illinois' ban on public transportation. And was SAF involved in that in some fashion?
It's an SAF case. Yeah,
it is an SAF case.
FPC might be on it as well. It's hard to remember who's a plaintiff on each one, but
a lot of warriors jumping in on things, which is cool. But the 7th Circuit, which always comes up with creative rulings, at one point says that analogical reasoning under Bruin demands a wider lens. Historical regulation reveal a principle, not a mold. That was a little problematic.
Well, yeah, it is problematic because what Bruin said about sensitive places was that, first of all, there's this general right to public carry that applies in almost every place. That's the idea. And then there's this rare exception of sensitive places. And the ones they cited as an example were courthouses, legislative assemblies, and maybe voting places, right. Places where government decides what it's going to do in essence. And now we're using looser and looser principles or analogs like crowded places and children are present and that sort of thing.
Right here. Here it is. Illinois' public transit firearm restriction is akin to the tradition of regulating firearms in crowded and confined spaces. I was not aware of that history, but you geek out on this stuff more than I do. Why don't you tell us?
Well, I mean, there is no history of it. What they're pointing to a couple of times is these stray ordinances. I think there was one in New Orleans about ballrooms, and fandangos, as they called them. But most places didn't regulate it. And in fact, this came up in Bruin. I think Chief Justice Roberts made a joke because one of the lawyers was arguing about carrying in New York City. He's like, well, where else? And the New York lawyers basically said, well, they can carry out in, when they're hunting or whatever it was. And Justice Roberts says, and what are they going to defend themselves against? Deer? Like the
Right.
place where you need to be armed is crowded, confined places. If it's not crowded and confined, I'm not saying you never need to use self-defense, but it's going to come up more in cities and such.
The probability of needing it increases the more people you have there.
Obviously.
Right. And the greater access that public has to that location as well. A crowded private event is not nearly as dangerous as a crowded public event.
Yeah, and their fear, if you're going to try and steel man their argument, it's, well, even if the person there means no harm, if you have a gun and there's a crowded place like a subway and you start firing, it's very dangerous. But they don't really cite very many or any examples of this happening where someone with a CCW permit or otherwise lawfully carrying just flies off the handle and starts firing. There's more incidents of cops doing stuff like that because they have qualified immunity, whereas people who carry generally are aware, or at least vaguely are aware, that they're responsible for every shot they take. So I'm not saying it's never happened. I'm sure it has, but it's a rare
thing. But if it had happened with any level of even mild frequency, we would have seen these examples cited over and over and over in the memorandums that we've been reading.
Absolutely. And they don't, and that omission is telling.
So, because they're claiming, the Seventh Circuit is claiming, that the regulation in crowded and confined places is ensconced in our nation's history, and any location where firearms can be banned is accurately described as a sensitive place. It's almost like putting the cart before the horse on that one.
Yeah, the whole you can only ban firearms in sensitive places according to the Supreme Court. So if you're just going to say that anywhere you ban them is sensitive, it's hopelessly circular.
That's a terrible position to be in. Now, this was, I believe, on the petition, because you guys are the ones that have petitioned on this case, correct?
Yes. Okay.
So one of the arguments you made, this is a really good argument, is there needed to be some attachment to some type of historical tradition. And the argument that was kind of advanced there is it's the historical tradition of these sensitive places are places where government's actually willing to provide security for you at those locations.
Yeah, we think that functions both strongly as a historical principle and as a practical idea that, if there's security there, if the government's providing it, like think airports, courthouses, then that at least mitigates the concern of being left defenseless. Well, everyone in here, at least ostensibly, has had to go through a metal detector. So,
well, it also demonstrates that government believes the activity itself that's occurring is so sensitive that it requires armed guards.
Yeah, it proves at minimum. It proves that they actually think it's sensitive, and not just saying, like California did, declare everywhere sensitive. Parks, bars, places that sell lotto tickets, like all these absurdities. And they don't actually think they're sensitive, because if they did, they'd put armed guards everywhere. Now, we need to be careful. There's a balance to this. We don't want to say the government can just transform any place by adding security, because that gets a little absurd and it has police state implications. But operating in good faith, with that in mind, within reason, basically, having security at a place is a good way to tell if it's actually sensitive. And that's the case in history too. A lot of these places, legislators, voting booths, courthouses, had security.
Well, you actually go back, if you want to go back all the way to the King's Castle. Last time I checked, they were guarding that with armed guards too.
Absolutely.
Yeah. So sensitive activity going on there as well. Okay, so now listen, on the Schoenthal case that we were just talking about, the response brief is not even due until December 4th on that. So we're probably looking at a conference, maybe around Christmas time, but likely getting kicked out to January at that point.
January is usually when it gets, probably around then.
A case that's on conference in January, how likely can it? When would it likely be set? Late in the term, then 26, spring of 26.
Probably, although they could push it to the following year if they wanted to grant it. I think what's more likely, and you're always going to hear the truth from me. I, of course, want all good 2A petitions, especially SAF cases, to be granted. I think what's more likely is this is going to be, if it goes well, a GVR after Wolford, because Wolford is not exactly on point. We contend Wolford's not even a sensitive places cases. It's about the vampire rule. But I can see how the Supreme Court might just lay out some ideas.
So, that's a good. I mean, that's a little sidebar we'll go on here. So, listen, Wolford v. Lopez, which was not on tonight's agenda, but we'll talk about it anyways. Which is the crazy private property open to the public in Hawaii's vampire rule, which was opposite of a think what you guys were doing in California. So they strike one of them down and the other one's held up. But do you really think it could have that broad of an application that you could see all of these challenges, the sensitive places and all this other stuff get GVR'd because of the holdings of Wolford?
Just sensitive places. I mean, who knows what the Supreme Court will do, but they like to GVR things. Like
Yeah,
they GVR'd a bunch of cases after Rahimi that, and sure enough, all these courts are pretty much issuing the same decisions again. So
didn't it do the same thing after Bruin too? And here we are again.
At least Bruin made sense though, because Bruin transformed. I mean, we argue that it's just Heller again in terms of the historical test, but at least they were correcting, over a decade of wrong cases. So it kind of made sense. Rahimi, the GVRs didn't really make sense. It was just them punting, I think.
All right. So you think that Wolford, do you think the same would go for the litany of challenges to 18 United States Code 922 G1 felons, those who got convicted of an offense more than a year? Again, with Wolford, that's not going to have any effect on those, right? We're going to have one of those cases get accepted.
I could see those being GVR'd for Himani, not Wolford,
Even though
Himani's not directly on
exactly
point.
Right.
Yeah.
No, it's not. Okay.
Yeah.
Well, we're going to talk about another one of those cases, but here's what else I wanted to talk to you about. So apparently we got a new Glock series coming out. Congratulations to the folks over at Glock, the Glock V. I was a little surprised in the 2A sphere that we all circle around in how much criticism there was of Glock. They caved to California and all of this stuff. What was your first initial reaction when you heard what they were doing?
First of all, if you're going to say they caved, they didn't cave because of California. They caved, if they did cave, because of the lawsuits. The lawsuits in many states, and a couple of judges who I think incorrectly refused to toss out those cases. So now Glock is facing down lots and lots of litigation, even if they win at the end, and they will. Because they didn't do anything wrong, somebody's illegally modifying their guns, but they'll still be on the hook for all those lawyers' fees. So I think Glock just gave into financial reality and decided to do this. I don't have any details because Glock all gun manufacturers are pretty quiet, but they're like especially quiet. They don't like to comment on anything. They're very Austrian. They're very keep to themselves. So. But what I suspect happened is they were looking at those lawyer fees and then they backed out. I think the California thing's a sideshow. Of course they don't want to lose the California market, but the timing of this wasn't. I think people are falling for the timing. They see California ban them, and then they see Glock came up with a V.
Right, and this redesign had to be going on for a couple of years, probably. Yeah. This is not just something that someone drew up a couple of months ago, and here we go. We got them in mass production already.
Yeah, no, it was like a week or two later. There's no way that the Glock Gen V stuff happened in that short a time span.
You guys got that goofy little handgun roster down there in California. Mm-hmm. How's this going to play out with that down there?
All the Glock Gen 3s, because of AB 1127, will be removed from the roster starting, I think, January. Well, the law is weird. So the gun stores can not receive any more shipments of Glocks after January, but they can still keep selling anything they have in inventory till July. But of course, all of them are going to be gone by then. So once you cut off the supply,
they've probably been flying off the shelf already.
Yeah, so they started basically a panic buy essentially. So they're selling every Glock they can get their hands on right now. But yeah, so it'll be removed from the roster, not because of the old reasons, but because of this new requirement. However, AB 1127 also has this unprecedented provision when it comes to the handgun roster, where it says if Glock fixes this issue and other affected platforms like Shadow Systems and Daria, the Glock clones.
Yeah, just the Glock clones, right?
Yeah. If they can fix this issue, they can get back onto the roster without adding a magazine disconnect and a chamber load indicator, but nothing else about the gun can change. So for Glock, that means you would basically have a Gen 3 with a different trigger assembly, I suppose.
Yep. Well,
yeah.
Yeah, well, there's a lot of people who are trying to figure out what are these new Glocks going to look like, or what it's going to be about. And what we know is that in the legislation, as well as in the litigation, the lawsuits, the big focus was on this cruciform trigger and the ability to easily attach it to the back plate. Yeah. That was what was written in AB 1127. That is what's been articulated in all of the lawsuits. And so if for those of you who are wondering what the new Glocks are going to have or not have, you really take no look no further than any of the lawsuits or what I've showed you right there, which is Assembly Bill 1127 and some of the language there, that's probably what we're going to be dealing with. Agreed?
Yeah, and I think some images leaked yesterday or the day before of what the new cruciform trigger bar looks. It still has a cruciform, which I'm not sure how that plays into California law, except that the definition doesn't just say cruciform trigger bar. It says cruciform trigger bar that can be modified, blah, blah, blah.
Be modified.
So maybe they can get back onto the roster pretty quickly here. And if so, that'll be a relief to a lot of people. But
is there a pre-approval process that Glock can go through to get the V series pre-approved before it actually hits the stores?
Any gun that's on the roster has to go through 2 laboratories that are available, and they submit it. And this one will have weird exceptions because, like I said, they won't have to do the chamber load indicator, but they'll still have to do all the drop safety testing, the fire it thousands of times, blah, blah, blah. So they'll have to go through all that to get on the roster. So, because California makes sure they don't call them safe handguns, they call them not unsafe handguns.
Well,
because no gun is safe.
But you guys are saving lives down there.
Yes, for sure.
Just want you to know that you guys are saving lives. Okay. It's conference time. We talked about this a little bit at the very beginning when we first went live here, but and I did a video about this. There are a ton of cases coming up, especially this Friday, the 14th, as well as the following Friday, the 21st. And we're going to talk about a couple of them, but one of them is this case that I will tell you what got me turned on to it was an amicus brief by a bunch of public defenders. This is Duarte versus the United States. It's a case I'm sure you're intimately familiar with. It comes out of the Ninth Circuit. Is this an SAF case as well?
No, this is a criminal defendant case. And yeah, the long and short of it is the 3-judge panel got it very right. They got it exactly right. And as is tradition, it was reversed en banc in the Ninth Circuit. So now we're going to the Supreme Court, not we, but the petitioners, and we'll see how it does there.
But there's a real interesting issue here. And this is kind of what I want everyone to be aware of, is that this isn't just some challenge to the overall constitutionality of United States Code 922 G1. This is also a very specific question as applied challenges even legally permissible? Because the Ninth Circuit en banc panel believes that's not the case.
Yeah, and they basically ruled that, Congress can have some categorical power to just say this whole group of people is dangerous. And that's absurd because, a lot of things that we call even felonies nowadays, let alone misdemeanors punishable by over a year in prison, are not anywhere near dangerous. So it's possible what I could see happening is if we get what I'd call a good ruling in Hamani, which is a damage mitigation ruling, and the Supreme Court says, well, Hamani can be disarmed, but not because he smokes marijuana, but because he's dangerous, and that could be where they reverse Duarte through a GVR and essentially say, no, this isn't a categorical thing. You have to determine if the individual is dangerous, which would reaffirm Rahimi, everyone's happy sort of ruling. I don't know if the government's happy, but that could be a possibility.
But this is the thing I need the viewer to understand is that, like, for example, the public defender brief talked about between 2000 and 2007, the United States government added on average 57 felonies a year to the United States Code, many of which were not violent. States, of course, have been piling these up. In the 1940s, we had roughly 2 million Americans with convicted felonies. Today, we have somewhere between 20 and 24 million. And it's not just a product of more enforcement as much as it's this huge swelling class of things that we define as felonies. And if left unchecked, why couldn't a state like California or Washington, since we're behind enemy lines, why couldn't they just turn everything, call it a felony, say you could be punished for more than a year? Nobody's ever actually going to be punished that way. But because the label alone can disarm you, and there's no way to have a court go back and kind of double check and be like, oh, you stole a cell phone 20 years ago or something like that. I'm not condoning the activity, but are those people truly the type that we meant to disarm for life?
Yeah, and that's the problem with the Ninth Circuit's ruling. And it's an obvious problem, but I think the Ninth Circuit is just hoping that the Supreme Court, they can't overturn them all, as one judge who used to antagonize the Supreme Court used to say. Forget who it was, but that's, I think, how the Ninth is operating right now. They're just trying to subvert and undermine Bruen and Rahimi.
It's a real healthy American justice system when we got that going on.
Well, I mean, a lot of courts don't even seem to know what the Constitution is, but I don't want to drift off into off topic right now.
Well, we're going to talk about another case, but when we're going to talk about this case, we're going to go ahead and bring our guest on to the stage too, because after all, he is the top voice of the 2A. And if you're not geeking out on Four Boxes Diner, y'all should. He does a fantastic job. Good friend of mine. Mark Smith, welcome.
Hey guys, thank you. It's a great honor to be here.
Well,
Your
thanks
second
for
show. Congratulations.
Thank you. Yeah, well,
I hope I can add value tonight.
Well, we haven't.
You guys are here. I don't know why you need me.
Well, because you geek out on this stuff with us, and we just figured we'd get a couple of different perspectives. And one of the things we want to talk to you about is this case coming up on November 21st for conference. It's a case that I know Kostas is abundantly familiar with. Mark, you are too. It's the granddaddy of them all, as we call it, Duncan v. Bonta. I think this case was actually filed in 2017. Kostas, is that right?
Yeah. I was at Michelle and Associates for 6 years, and it lasted longer than my whole time. It's just going.
And how many times has it been GVR'd once or twice?
It's been GVR'd once. It did go up and down the Ninth Circuit 2 or 3 times. So it's had quite a long history. I don't think any case has a longer record than Duncan, if that's really what they wanted.
Well, Mark, let me ask you this question first. If the Supreme Court is looking for a case that has percolated, is there any case in American jurisprudence right now that's percolated any more than Duncan v. Bonta?
Well, no, but I think the reality is that the Supreme Court is going to want to take an AR-15 case next. They're not going to go with a magazine case. With that said, I think the best we can hope for is that they may issue a per curiam ruling like we saw in 2016 with Catano, where they specifically say that as a plain text matter, that a magazine is indeed an arm on the plain text, but they will not go on and then answer the ultimate question of whether or not this is in common use and all that. But so I think that's the best we can hope for the Duncan. Now I know that out there in California, a lot of people want to make sure that they don't have to give up their magazines. So as a consequence of that, I do think there's a good chance the court will sort of drag its feet and not actually deny cert. I think they may hold on to this case and then GVR it so that those people in California that have magazines don't have to turn them in. I think that is sort of the best case scenario. I think, again, the best case scenario is a Catano style per curiam decision that says, look, magazines at a plain text level are indeed arms, and then go back to the lower court and figure out, the historical tradition rules, which is really just applying Heller. I think that's the best we can hope for here. But it's pretty clear the Supreme Court wants to hear an AR-15 case next, which is why
do you think that?
Well, it's just read what Justice Kavanaugh said in denying cert and Snow.
I know, but he was the only one that said it.
Well, that's okay, because he was also the only one that indicated the same before Bruen. If you remember in 2020, Justice Kavanaugh also said, it seems like we should take one of these like carry cases to determine whether or not the right to bear arms means you can carry a gun in public. That's what Brett Kavanaugh wrote in 2020. And 2 years later, we won the Bruen case. So when Justice Brett Kavanaugh, who's, I would say, a conservative, and I don't mean political conservative, I mean kind of a conservative traditionalist. If Justice Brett Kavanaugh is coming out saying, we're going to hear an AR-15 case real soon, the next term or two, I think we take him at his word. Because again, he's not a hyperbolic kind of guy.
Kostas, let me ask you this, because you and I have geeked out on this privately. Do you think that's the case, or do you think that the United States Supreme Court might be more inclined to take a magazine ban case, make a ruling, and GVR all the assault weapon ban cases?
Logic. I feel, in my opinion, I think magazines are less controversial because they're a magazine, and you could even frame it around the pistol instead of the scary AR-15. You could say, well, Glock 19 mag, that's 15 rounds. It's a normal thing to have. But I will say I've come around to Mark's pessimism on Duncan, and that's because of the Hamani grant. Once they granted Hamani, I'm like, they're not doing 3 second. I hope I'm wrong.
Mark, does that play a little bit into your equation too, knowing that we got 2A cases already going up there? Is there a bandwidth for a third or fourth?
Yeah. I think there is bandwidth for a third, but I think that the third case is going to be one of the young adult cases. Yeah. And the reason why I say that is because you're dealing with a federal law that says that young adults, meaning Americans between the ages of 18, 19, and 20, are not allowed to acquire handgun from an NFL. That is a circuit split, number one. It is a federal law at issue, number two. And I think, frankly, the young adult case is relatively easy for the Supreme Court to decide, given, among other things, the Militia Act of 1792. So if they're going to take a third case on the merits, I think you're looking at the young adult case. There's several of them. I don't know which one they'll take.
A couple dozen they can select from, yes.
I think they'll take the federal one. And I think the one, if they're going to take a young adult case, and this is a nuance I do want to mention for the viewers out there, we want them to take the case involving the federal challenge. We don't want them to take the case out of the U.S. Court of Appeals for the 11th Circuit, which is the Florida gun ban, really.
And our AV glass.
Yeah, we want, right, the one that Judge Bill Pryor screwed up, but set that issue aside. What we really want is the federal case, because if we win the federal case, it also gives us the right to acquire guns as covered by the text of the Second Amendment. And if we have the right to acquire guns, because remember, the federal case is your ability to buy a handgun from an FFL. If we win the right to acquire as part of the plain text of the Second Amendment, that, of course, is the next step we need to have the fundamental right to make our own guns, which speaks to the so-called ghost gun issue, which we know the anti-gunners are all hot to trot on.
They love that one. They love that one.
I will say on Duncan real quick before we move on from it too much. One of the things our amicus brief suggested for the Second Amendment Foundation was, look, Supreme Court, if you're not going to grant this one, just hold it forever. Hold it until you do an AR-15 case next year or the year after. I don't care, because what would be a disaster is if they send it back down and mandate issues, and then all these magazines are illegal now and we have to turn them in or get them out of state, and then in a year or two they decide this issue. That would be incredibly frustrating. So I really hope they take our suggestion. If they're not going to grant cert or per curiam, just hold it. Just hold it until you do that. But I think Mark's right, because there's also hints, Kavanaugh specifically cited the 7th and 3rd Circuit cases that are coming. And I probably don't see a universe where they don't just wait for those now, especially given DOJ's involvement in both. The Supreme Court loves when the federal government's involved in a case.
Yes, they do.
So I think they're just going to wait and see. And there's a good chance of a circuit split now. And they love that too, So
that's right. Because out of the 3rd Circuit in the Cheeseman case, we could end up with a positive ruling for our side, and then we would officially have the circuit split. Right now, you got Viramontes out of the 7th Circuit, and then the Lamont case, which is actually an interlocutory fashion out of
and then we filed one too today, also interlocutory. But I think it's not even if the 3rd Circuit somehow went against this, I'm still pretty sure we can take Kavanaugh at his word that they're going to do one of these cases, but it makes it more palatable for them. It breaks my heart because I worked on Duncan and it deeply affects those of us in California. But I think I'm starting to look at it a little more clear-headed and not emotion-driven, and I think it's probably not
emotionally invested in it. That's why.
Yeah, I mean, I worked on it, and the case is old, and it deserves to be clear. I still think
Mark, Mark, you've been emotionally invested in a case where literally that weekend when you're getting ready for trial, you convince yourself that you can win the damn thing.
Right. The other thing.
Then about 2 weeks later, a jury corrects you on that, and you're like, "Damn, I really thought I could win that one."
Yeah, the other thing that it's worth mentioning is one of the critical decisions involving AR-15s is that Heller 2 decision by the U.S. Court of Appeals for the D.C. Circuit, where that dissent by then Judge Brett Kavanaugh found that AR-15 semi-automatic rifles were protected arms under the Second Amendment. And as a consequence, the D.C. ban on AR-15s was unconstitutional. That was a decision that then Judge Brett Kavanaugh decided in 2011. The reason why I mentioned this in discussing Duncan is in the very same opinion, guys, Judge Kavanaugh literally said, as to the magazine question, I'm not really sure what to do about this. I would remand that for further fact-finding, which tells me the Justice Brett Kavanaugh was a little unsure how to handle the magazine question. So if I could sketch out the plot in the real world, the way I would probably sketch this out is that the Supreme Court rules in our favor for semi-automatic rifles, AR-15s, which I think, frankly, is a slam dunk in our favor, since every one of the 9 sitting Supreme Court justices has indicated in one opinion or another that AR-15s are commonly owned by Americans. Literally, even the liberals admit that. And I'm just counterintuitive, but then I would want the Supreme Court to rule on a suppressor case. because a suppressor, there's no argument whatsoever or no sort of emotional appeal that suppressors are sort of dangerous or contribute to mass shootings or any of that nonsense. So I think I would go AR-15s, then I win suppressors, then I would use the suppressor precedent from the Supreme Court that says a suppressor is an arm and cannot be banned, and then I would go after magazines. I think that may be the sequencing that this Supreme Court is looking to do. Now, that may take 5 years or so, but I think that's
5 years and
sequence.
a change in the bench during that time as well.
Well, you don't know what's going to happen. I still think we're okay with the Supreme Court. I think we're okay with the U.S. Senate. Just keep in mind, and I know I'm going to digress just briefly, but it speaks to the Supreme Court in a big way. You know, if you look at the Trump wins, Trump won 22 states 3 times in a row, 2016, 2020, 2024, by a margin of more than 8%. Then he also won Texas and Florida. If you take those 22 states plus Texas and Florida, you have 48 Republican senators. That means you just need to pick up 3 additional Republican senators from states like North Carolina, Michigan, Wisconsin, and so on. And I only mention that because as long as we control the U.S. Senate, it allows President Trump to get his nominations through to the Supreme Court. So when William Kirk is nominated, we'll have the votes to get him on the Supreme Court.
Yeah, that's not going to happen, but I appreciate it all the same. Thank you. Thank you. Well, listen, I mean, just real quick, that 2016 election that Trump won, Trump 1.0, and the 3 justices he got to appoint, you take the Second Amendment out of it. Take a look at some of the other cases, like the Mahmoud v. Taylor case, the Planned Parenthood case, some of these other cases that were decided in the last term or 2. Take 3 justices, change them into liberal justices, and we are definitely living under an entirely different world.
Yeah.
So, Mark, I don't know if you're a big pot smoker. I'm not going to ask you here on the record anyways. If you are a very intelligent pot smoker, and I'd say very impressed.
Whatever, dude.
Yeah. But I'm in a legalized state. Kostas is in a legalized state. Are you in New York today? You up in New York?
Oh, no, not today. So I try to, now that it turns out that there's a communist running New York City, I'm trying to avoid that place, right?
Yeah. Yeah.
Like everyone else, every other American that has a brain has said, well, maybe we don't want to go there anymore.
Well, listen, here's the thing for guys who live in legalized states like Kostas and I. First of all, there are 24 states where legalized cannabis for recreational purposes is there, and there's another 14 states that allow consumption for medicinal purposes. So you got 38 states, and every one of these people has to go in when they want to get a gun because they think their life is worth preserving, and they got to go through the 4473, and in section 21 you got the no questions, and of course now you have this Hobson's choice. And it's an issue that really, really, really needs to be resolved, because I think the only tradition we have, historically speaking, is that you are disarmed while you are under the influence of substances. And I don't really think there's a lot of debating that. But then we get Hamani as the case to decide this issue. And a case, by the way, that I would point out that there was a bunch of these floating around, and I think DOJ stepped in on that one and said, hey, y'all ought to take this case here. So is the fix in on this issue in the sense that this Department of Justice is still hell-bent on the pot smokers and the guns, or what say you?
From a big picture point of view, William, I think the way to understand what this Department of Justice is doing is their view is that they want to do whatever they can to protect the right to keep and bear arms when it comes to law-abiding citizens. So if they see some overreaching gun control statute, they intend to step in. At least that's kind of my general gist of what's happening here. They intend to step in and try to fight for the right to keep and bear arms, which we saw in suppressors, magazines. We saw that in the 7th Circuit and the 3rd Circuit cases involving AR-15 bans and the like. However, when it comes to criminals, and, it is illegal, marijuana is, I believe, a class 1 drug under the relevant schedules here. When it comes to criminals, they're not going to be sympathetic. They don't want the criminals to have the guns for a whole host of reasons, because this is a law and order administration, and they understand that letting criminals run around and do terrible things is not just bad for the people that are victimized, it's also bad for the Second Amendment, because remember, where our greatest risk is, the moment in time that we in the Second Amendment community are always at the greatest risk is when some psychopathic, wackadoodle, nutjob criminal goes out and misuses a firearm, and that gives rise to calls for more gun control. And I think the administration is aware of this. So yeah, I think we're going to see this law, 18 U.S.C. 922 G3. It's going to be upheld as constitutional. They're going to find that this is essentially speaks to physical dangerousness. And I think they're going to say with respect to Mr. Hamani that it's applicable to him. Now, I think there's a silver lining here. And again, it's not if I were running the Department of Justice, would I push the Hamani case and the pot case at the Supreme Court? I would not have. This is not what I would have shoved to the Supreme Court. I would have looked to shove more favorable fact patterns in favor of the Second Amendment to the Supreme Court. But this is what they decided, and here's where we are. I do think there will be an opening after they rule against Mr. Hamani in this case. I think there will still be an opening for individuals. And this comes into the issue where people are legally allowed to get a prescription for medical marijuana, whatever it is. I think they will have the ability to essentially assert an affirmative defense to say, look, I understand that law, that federal gun control law is constitutional. It's not a violation of the Second Amendment, but as applied to me, I am not a physically violent danger in any respect, and therefore, if you apply this law to me, that would violate the Second Amendment. I think that's where we're going to wind up in terms of what the law is going to say and how the Supreme Court's going to come out.
Well, I mean, the easiest solution is take it off of Schedule 1, but nobody seems to have the will to do that. So,
that's correct. Yeah, I mean, obviously, that's a little bit of tension because there is discussion about doing that, but I think there's push and pull in the conservative movement. You got the libertarians that want to. They want to take it off Schedule 1. And then you have the law and order conservatives are like, look, pot is a very big danger. And every time you use pot, you kill brain cells. And that is extremely dangerous and bad for society. So there is a push and pull on the Republican side of things, if you will. And right now it is a Schedule 1 drug. It is there. Right. And this is an as applied challenge. So he's probably Mr. Hamani will lose this case.
I agree. Kostas, Hamani's cooked on this one, don't you think?
Oh, he's definitely cooked. Look, this is one of those things, though, where two things. Just because something's illegal, it doesn't mean it should it shouldn't cost you your firearms rights. Rahimi just said the metric is dangerousness, and people who smoke weed typically aren't dangerous. Hamani might be dangerous. Guy's got like terrorist ties and all that. But I will note that they're not charging him for the terrorist ties or the drug dealing. They're charging him for possessing weed. So all that other stuff is kind of irrelevant, and they're just saying it to poison the facts, which I wasn't a fan of. But second of all, the conservative movement, I know this is a bit of a sideshow, but there is no future where in 20 years from now, weed isn't legal nationally. It's going to be legal nationally. The polls, I just researched this because we did an amicus brief, 90% of Americans support either full recreational legalization or at least medical legalization, 90%. And, we're talking about almost 40 states now. So they just need to say this way the wind is blowing. But how this ties back into the Second Amendment is it's kind of horrifying to take someone's firearms rights for something that everyone kind of knows is on its way out, which is marijuana prohibition, And I wouldn't use these blanket bans and say, well, you broke some rule. And because it's a rule and we said it's a rule, that means you can't have your Second Amendment rights. I hope that's not what the Supreme Court rules.
Well, I will say one thing. And by the way, again, I make it very clear. I would not 100%. I would not have pushed this case to the Supreme Court. I made that point at, like the Gun Owners of America event, Second Amendment Foundation event, and so on. This is not a case I would have pushed if I was running the Department of Justice. I would not. I just not. And I should note that, if you look at the number of prosecutions under 18 U.S.C. 922 G3, it's only a few hundred a year, as opposed to the thousands that you see under 922 G1, which is the felon in possession law, right? So it's kind of like, well, why are we dealing with this? But I'm going to push back on one thing, and that is factually this. If you look at the statute, let's step back for one moment. The Supreme Court in Rahimi says that if you are a violent danger and you are found to be a violent danger, you can be temporarily disarmed. Temporarily disarmed. That was the holding in the Rahimi case by the Supreme Court. So here, let's say I'm a marijuana user, or I'm an illegal drug user, and or I'm an addicted to the drug. If tomorrow I wake up and say I'm no longer going to use this illegal drug, and I'm no longer going to be addicted to this illegal drug, well, going forward, I'm no longer a danger. Basically, I control the ability to choose whether or not I use the drug. I control this ability, whether or not I'm addicted to
What
this
if that
drug.
drug's being prescribed by a doctor for pain management because you're
Right.
a wounded veteran, and rather than, taking all those opiate-based painkillers, because we all know where that goes, the doctor's like,
Right.
no, I think we ought to treat it with cannabis. And the patient is also finding like, hey, this is working, and I'm not destroying my liver and my
Right.
kidneys and all of that. And now he's got to choose, he's got to make that Hobson's choice between, do I take care of my health and follow my doctor's orders, or do I get to preserve my life? That's a tough position for an American to have to make in the in the 21st century here.
But there is a third option there in that situation. So let's say you are dealing, and I think this is why it's very important. Again, I'm not defending all this. I'm just making an observation.
What's the third option?
The one good thing here is this as applied to Mr. Hamani, right? They're not saying everything always for everyone. The third option is simply this. You would have the ability to sue civilly and say that as applied to me, this statute should not apply to me because, and I want an immediate injunction as applied to me. I'm not saying the law is unconstitutional as applied to the world. I'm just saying as applied to me, I have this medical marijuana card. I have this problem from, my youth or whatever it is, a car accident. Now I have a bad back and I need this to be able to sleep, and I'm not physically violent, dangerous. You could bring a civil lawsuit seeking an injunction of that law.
Yeah, if you have the
to
resources to bring that kind of lawsuit.
Right, of course, that's correct.
Yeah,
but I do think, I think what's going to happen here, and again, the way I think this is going to play out, and like I said, it's not like I sketched this out and this is what I'm saying is the best option. It's not. But after this decision in Rahmani, I think what you're going to see is a whole host of as-applied challenges on much more sympathetic facts. And I assume that Kostas is going to be involved with some of these. It's just my guess.
Yes.
And they're going to bring these kinds of lawsuits in these jurisdictions. And I think you get a lot of favorable rulings, which will build up the precedent that says that if you're addicted and or use an unlawful user of marijuana, but you have a prescription card, then we're going to enter an injunction that says you can have a gun and continue on. Again, that is a best case scenario. But this is what this is what I think we'll be looking to do down the chessboard. Again, this is like the best you can play this hand, which again, I don't think is a great hand, but
no, this is a crappy hand. This is Hamani is like Rahimi 2.0.
Yeah,
it's just like, and what do they teach us? And all three of us are lawyers, so we all learn this. Bad facts make for what?
Right? Yeah,
that's right. So here we go. All right, Mark.
I agree with
Mark. I got one for you here.
Okay, go ahead.
Now listen. I think let's get something out of you. Have been a huge supporter of the Trump administration and this particular Department of Justice. Don't think there's any debating that. You and I have had private conversations. I am a supporter of them. I don't think I rise to the level of you, but that's, again, you could be right. I could be wrong, whatever. But there's this case out there, this one right here, Firearms Policy Coalition v. Bondi. And what the whole brouhaha about is about the remedies.
Right.
Okay. Kostas, you guys in on this one too? Or is that FPC's case?
Yeah, no, Second Amendment Foundation is in on it too, and I have a nuanced take on this one as well, but I'll let Mark go first.
All right, well, okay, so as one of the litigants, Kostas, why don't you give us your take on it first, and then Mark, I want to hear your take on it.
The basic thing that's happening here is we're caught in the crossfire. This is not about us. It's about the immigration cases. It's about injunctions in general. And we are caught in the crossfire of a bigger dispute, and they can't cede any ground to us because then they cede ground and it becomes precedent on other issues. Now, I have certain suggestions that I'd love them to take, like settling out of court with us about scope of relief, which would help the situation. But the idea, what is false, I think, is this meme spread, and a lot of people were outraged about it. And I get why they were outraged about it, that they were demanding our members lists. That's not true. I mean, they suggested it. That's true. And maybe they shouldn't have even suggested it, but they
actually asked for it.
We need to know how we enforce this, who's exempt. So do you want to give us your membership list? And we said, no, of course, because we're never going to do that. And they said, okay, fine. And they went to the judge and explained the situation. Now, what I would say to them is, just let, if you charge someone and they affirmatively prove after you charge them or after you arrest them that they're a member, just let them go, or stop enforcing it altogether. But we know they're not going to do that. So that's my nuanced take. I have some frustrations with them, but what is being said that they're trying to force us to give out that's not true.
Right. Or they're trying to create a gun registry through that information and all that crap that came out there.
And maybe they shouldn't have even asked, like I said, but there's a bigger fight here. It's not really about the Second Amendment, and we're in an unfortunate situation, which I hope will be ironed out
Okay,
soon.
before I turn to Mark, I want to ask you a clarifying question here, though. Okay, because at first it was, oh, they asked for this information. Then Department of Justice, like, oh, no, we never asked for it. And then when they did their follow-up brief about remedies, they openly stated in there that they had, in fact, requested that information. Now, they didn't demand it. And of course, you can't demand it. But I just want the record to be clear. They did ask, to the best of your knowledge, they asked for it. And you guys told them, thanks, but no thanks, right?
Yeah, exactly. Yeah, so they asked for it, and which is fine. You know, a lot of stuff that isn't required, lawyers will ask for. You know, to
see if they're willing to give it. No doubt about it.
And
okay,
of course,
Mark.
they're never going to give out membership lists, so it was a hard no. But I think it's an exaggeration to say they demanded. It sounded very dystopian, very 1984. You know, come on, guys. Like, there's legitimate criticisms here, and I just made them, and I've made them online without flying off the handle and saying insane things. You know, so
fair enough.
We try to be balanced here.
Mark, what did you see when you were watching this whole thing go down? What was your observations on that?
Well, we understand that the Second Amendment community is clearly collateral damage to the ongoing lawfare against the Trump administration, involving everything from federal employees to, you know, nonprofit organizations trying to get grants, to universities wanting their money, to immigration and ICE. So we are collateral damage. Now, the right answer here is what's always occurred is if you have an organization with members, then you enter injunctive relief for the benefit of the organization and for its members. And in the event down the road, a member gets crossways with the government, is, you know, say caught with a gun in a post office, they would be able to say, well, you know, that injunction down there in Texas applies to me because here's my membership card, or here's my affidavit that says I was a member and I'm covered by that injunction. Therefore, you cannot enforce this law as to me. So what I think is happening here, and what the DOJ is saying, and I think, again, this is not really the right legal position, although I understand the motive here, which is trying to combat this sort of anti-Trump lawfare, is they're basically saying, look, we need to know who we can enforce this law against and who we cannot. And the best way to do this is for us to know who these people are. And if you don't want to disclose it, you have no obligation to disclose it. We're not asking for it. But if you don't disclose the list, then obviously the scope of relief in the injunction should be narrowed accordingly, because we at the Department of Justice do not want to be in a situation where we enforce this law against a member of an organization that's covered, and next thing you know, we are being held in contempt of court.
Right.
I think that would be their argument. I don't think it's a very
that was their argument.
That is their argument. And I don't think it's a strong argument. And I think as a practical matter, they're making these arguments to sort of save face so it doesn't get thrown in their face in other cases. I think the judges should follow the law that's been the law for many, many decades and just say, hey, this is the benefit of the organization and its members, and leave it at that. At least the DOJ cannot be thrown, you know, they can't basically in the district in Washington or district of California throw this in the face of the DOJ lawyers. And I think that's what's really going on here.
Okay. So if I'm hearing from both of you, even though you came at it from different ways, you guys are both kind of coming up with there's been a big deal made out of something that's not as big of a deal here. Agreed?
Let me clarify. It is a big deal because the scope of relief matters a lot. But
yes,
the dispute is not what is being framed. So I'm very annoyed that
when I say the deal, I'm sorry, Kostas, let me jump in real quick. When I say the deal, it's this whole demanding membership list and all that. That is a completely blown up kind of bullshit story.
Total side note. What's actually important here is, you know, for not the post office carry, but the other case this has also come up in, which is the 18 to 20 law. I think it's Reese.
Reese versus ATF.
Saying, well, it has to be people who are members in 2020, and that would be 13-year-olds. You know, it doesn't make any sense. So we definitely have serious disputes with the administration on this issue. I don't want to downplay that. We do disagree, and we do. You know, what I've been saying is, why don't they just settle out of court with us? You know, you don't want precedent on injunctions, fine. Come settle out of court and say, as to scope of relief, we'll settle with you that we will not enforce it as to your members nationally. Or, you know, and then there's no precedent and everyone's happy. But for some reason, maybe reasons I can't understand or I'm not fully aware of the law on, perhaps, they don't seem to want to do that. So we'll see how it shakes out. But there are serious disputes. I think people need to not feed into outrage and nonsense, you know, and
Understand what the
actual
disputes
issue.
really are about rather than what they think they're about.
Yes, exactly.
Mark, you agree with that?
Yeah, I think there's another sort of dynamic that's going on here, which really deals with the authority, not of the United States Supreme Court, but of district courts. I think part of the strategy of the Department of Justice is that we understand that we at DOJ can be enjoined, the federal government can be enjoined from enforcing certain laws, but to the extent we're going to be enjoined from enforcing certain laws, it really should be the U.S. Supreme Court doing it. We should not be in a situation where a single district court judge anywhere in America can enjoin anything with respect to the entire federal government. And I think that's part of the problem. Part of the issue here is that their view is, yes, we understand the law, but we think that we should really make it harder for single federal district court judges to do anything extraordinary. And I think that may be a little bit of pushback. And in fairness, there are comments that Justice Clarence Thomas has made over the years, raising questions whether or not organizational standing or associational standing, which is kind of what has been used for decades, whether or not there's an originalist basis for that at the time of the founding. I think there is, but even Justice Thomas has raised questions about this long before Trump 2.0.
Okay.
And this is going to need to be ironed out, because if it's not, what's going to end up happening is we're just going to have to bring cases as class actions all the time, and that's not what anyone wants. It's going to weigh. It's harder.
It's expensive too. It's expensive when you start doing it that way.
And Alito kind of Justice Alito predicted this in Trump v. Casa. He said, well, what's going to stop you from bringing class actions? And it looks like that's the way we're going. So I hope that this can get clarified soon, and they can firm up associational standing and what the rules are around that. You know, I hope it's just what it's always been.
Employment advice for any young, right out of law school lawyer who's watching right now. You might want to learn about how to certify classes.
Yeah.
to be a really wealthy. You ever do any of that crap, Mark? Did you ever do class action stuff? Or
Oh yeah, I've done a lot of class action work. I don't think that's how they will solve this problem. I think the way you solve the problem in the real world is, let's assume you get a bad rule, a very narrow scope of relief from a district court judge in Texas, let's say. There'll be an appeal, obviously, to the U.S. Court of Appeals for the Fifth Circuit. I'm just going to use Texas and the Fifth Circuit as an example here. You get an appeal to the Fifth Circuit. And let's say the Fifth Circuit upholds the substance of the law. As a practical matter, that ruling will be protective of everyone in the Fifth Circuit Court of Appeals, right? So even if you're not technically a party to that lawsuit, even if you're not a member of like SAF, you're still going to get the benefit, because let's just play this out. The U.S. Court of Appeals, which covers Mississippi, covers Louisiana, covers Texas, says it's, let's say, unconstitutional to ban guns in post offices. And then some guy who's connected to literally no one gets arrested in New Orleans in a post office with a gun. The first thing his lawyer is going to do, William, you know this, you're going to file a motion to dismiss on the grounds that the Superior Court, the U.S. Court of Appeals for the Fifth Circuit, says this is unconstitutional. And as a matter of precedent, you have to dismiss the case. And the district court is going to be bound by that and will dismiss the case. So as a practical matter, if you went at the Court of Appeals level, it's not going to matter the scope of the relief within that circuit. Now, it might matter for members of the organization in other parts of the country, but that's just going to require you to bring those lawsuits, not as a class action, but just to get a favorable ruling in those other parts of the country. I think class actions are a terrible waste of money unless you are suing for infinite amounts of money after a plane crash.
Yeah, like
toxic torture.
Yeah,
I think class actions are terrible mechanisms.
That was a good class action.
I mean, I've spent years litigating class certification before you even get to the merits. So I wouldn't touch a class action strategy in the Second Amendment context with a 10-foot pole.
But see what's happening. It depends. We saw this right after Trump v. Casa and Alito made that prediction. He's like, well, what happens if everything's a class action? And sure enough, some district judge certified a class in days. And I'm like, class certification never goes that quickly. Like, yeah,
right. Exactly. But that's all fake. That's all fake stuff, right? I think that was like a district court in Boston, and the Supreme Court and everyone else sees through that, because anyone that has experience in class actions knows that it literally takes a year plus, because you got to make sure that the class representative is adequate. That requires depositions of them. You got to make sure that the class lawyers are adequate and that there's no conflict. Then you got to make sure that their claims are representative. You got to make sure that the claims are a sufficient quantity. It's a whole mess.
The worst.
It's like ascertainability. Like there's all these factors you consider.
It's the worst.
It's a mess. They're a mess. They're very good. Look, you can make a lot of money.
Oh yeah,
doing
that's
them.
the actual advice.
That's why I'm telling you, man. Kid right out of law school, and then get to know Mark Smith, and he'll teach you all the ropes.
That's correct. That's correct. That's
Mark,
right. I'm quite familiar with that, but I would do it in the Second Amendment context.
I want to ask you something else before I kick you loose here about with DOJ. As you know, there are, no joke, 30, 40 cases challenging 922 G1 felons, right? And you got all sorts of different fact patterns, but most of them are, the range type case, nonviolent, long time ago. And then, of course, you have, with the reconciliation, big, beautiful bill, you have a refunding of 925C, 18 United States Code 925C, which I think got defunded when Clinton was president. And despite the fact we've had other Republicans in there since then, no one ever got it refunded. Now we have an opportunity for certain individuals, and I know the rules still awaiting final publication and things like that, for people to go back and restore their rights depending on what the final rule says and where they fall into that spectrum. But DOJ keeps using that as an argument to moot a lot of these cases.
Yeah.
Is that a fair argument?
Yeah, I think it is. And in some ways, it's like, in this context, it's like the pro Second Amendment view, which is there's no guarantee that the U.S. Supreme Court will rule favorably, even for a Brian range involving 922 G1, which is the felons in possession statute. So to avoid a possible adverse ruling, the right answer is what DOJ is starting to do, which is to use that restoration of rights process and use it robustly and start restoring the rights of possibly millions of Americans.
That just eliminates some of the potential plaintiffs, because just as fast as we refunded it, it could be defunded it too, right? Changing the White House here in 3.5 years, and all of a sudden, boom, it evaporates and we're back down to square one again. So does that really moot the issue for a lot of these people?
I think there's a couple of different ways that this could have been handled, but in the short run, the right answer is, given the Department of Justice's position, they should be restoring the rights once this rule is officially final. They should work to restore the rights of tens of thousands of people, if not millions of people, who have not been convicted of violent, dangerous crimes. The murders, the rapists is problematic.
Sure.
All those malprobatum stuff, and that's what they should be doing. And I should, technically speaking, Attorney General Pam Bondi has the financial resources, because what happened was not to get too boring here, but I'll just explain.
But you're going to do it anyway, so go ahead.
The Attorney General, a few decades ago, basically delegated the authority for restoration rights to the ATF. And then the step 2 of this process was that the Congress, the Democrats and Republicans got together and said that the ATF is not permitted to spend money on the 925 restoration process. So what Attorney General Pam Bondi did was she removed the authority from the ATF. She took back the authority to restore rights. And the DOJ has lots of resources, even if you want to starve the ATF. So now the DOJ Attorney General can restore people's rights under that 922 provision. And it doesn't really matter whether you starve the ATF for money, which of course should happen.
But as quick as that spigot got turned on, it can be turned right back off, couldn't it?
Well, no, but if you restore it, once you get your rights restored, they can't take the rights back. So that's why.
Sure, I get that. But there are going to be potentially millions of people that are going to get into the hopper. We don't know what infrastructure they have set up. We don't know what the turnaround time is going to be. We don't know what the criteria is going to be, because some people may be very obvious, like, yes, you will be restored. Other people may be like, screw you, I can't even believe you tried to apply. But then there's going to be this big chunk in the middle that are iffy, right? How are we, right?
That's where I think a future administration might mess with it, because what I'm encouraged about this, because yes, I was initially afraid, President Newsom might just reverse this entirely. But I'm seeing places like the Bloomberg School, who's very anti-gun, come out and support. And that's good, because it shows, if there's this bipartisan sort of consensus that some restoration should exist, that's a good thing. However, where President Newsom might mess with it is in that gray area you just described. They might make it much harder or apply to only a certain type of person, so that's definitely a concern.
Well, I think there's going to be two tracks here, right? The first track, as I see it, is going to be people, what were they initially convicted of? If you were Martha Stewart and convicted of lying to the FBI, there's nothing inherently dangerous at all about that. So if you've been convicted of something that has no kind of violence element to it, no dangerous element to it, nothing like that, then really you should have your rights restored. In fact, arguably, it was unconstitutional to deny you your Second Amendment rights in the first place. They should have their rights restored immediately. Where it will become more of a serious evaluation is if you've been convicted of murder, rape, robbery, some violent crime, 30 years ago, then I think there'll be a more serious vetting. But in terms of the people that were convicted of a crime that is non-violent right from the start, that should be an easy rubber stamp, giving them their Second Amendment rights back.
And that's a lot of what they're talking about, Duarte. You know what? I'm going to give you guys, and you can mark this day on the calendar. I'm going to actually give a compliment to a Washington state gun law. Ready for this? Our restoration laws here in Washington state are remarkably straightforward and not really subject to any interpretation or discretion. And the way it works in Washington state is if you get convicted of a Class C felony after 5 years, you can petition for restoration. And if you're eligible, the court shall restore you. And after on a B felony, you got to wait 10 years and you do the same petition and the court shall restore you. And if you got convicted of an A felony, screw you. There ain't any coming back from that. And that's just how it works. And if you look at what falls into the A felonies, at least how we score them here in Washington state, that's like, those are the offenses you're like, yep, nope, that's exactly the kind of stuff that the founding fathers intended to disarm people.
Right. The ones they would hang you for? Yeah.
Yes, the ones they would do. They would more than disarm you. Exactly. All right. Hey, Mark, real quick, before I kick you loose, why don't you tell everybody how they can follow Mark Smith, Four Boxes Diner, on Twitter and all that, in case they've been living under a rock and don't know how to do that yet.
Yeah, well, you can follow me over on X at Four Boxes Diner. You can check me out on YouTube, Four Boxes Diner, which is named after the four boxes of American liberty. And, feel free to check it out. And again, if you want super nerdy Second Amendment information, it's provided by a non-dapper individual, unlike William Kirk, then you should definitely check out the Four Boxes Diner.
You going to be in Vegas so they get to see you down there at SHOT Show?
That's the tentative plan, to get out there for the Gundys and everything else in January. But, that's the plan. I haven't done anything yet about it, but
we'll go out and have a Diet Coke together like we always do.
I just finished the Federalist Society in D.C., so now I'm looking for the next set of trips, right?
There you go.
I need to go to that next year. I didn't make it. I looked into it too late, but next year I'll try.
All right. Mark, you're a prince, man. Thanks for being here.
Thanks, guys. I appreciate it.
You stay safe.
Sounds good. We'll talk again.
Thanks, brother. Thanks so much. All right. Now Kostas, that is some serious geeking out right there, man. That is some serious geeking out. We got a couple of little sections left to do, and then we're going to get everyone out of here. Of course, our favorite one, although I think this is going to be the last time we get to do this, I understand, to live and die in L.A., or in other words, is Kostas ever going to get a CCW renewed by the state of California? So why don't you break the news to our viewers tonight?
I finally got today, actually, literally a few hours ago, I picked up my renewed CCW permit 44 days after my last one expired. So I've been not legally allowed to carry the last 44 days. I'll just leave it at that.
Well, and let's go back in our time machine, because you actually didn't apply like right as the thing was expiring. You had like a 4-month window, and you damn near got it as like the earliest possible date. So this is 4 months on the old plus 44 days with none, right? Yeah. So we're really at 5.5 months.
Yeah, I applied. They only let you apply 90 days early. I applied 80 days early because I was abroad. I was on vacation with family in Greece. So I came back, applied the next day. I got back 80 days, and I did my training right away. So as soon as mid-August rolls around and they ask for my training, I'm like, it's already done. Here you go. And then from mid-August to September, nothing happens. My permit expires, and as is happening to everyone right now, everyone takes about a month and some change to finally get their permit after renewal. It's absurd, and I've urged publicly and by email the sheriff to just say that expired permits, as long as you've applied for a new one, should continue to be valid. That's not in California state law, but they don't seem to mind ignoring California state law when it comes to the wait time. So why not just make up that?
Well, or when it comes to a lot of other things too, unrelated to what we talk about around here. That's true. All right.
Yeah, so now, that ordeal's done for 2 years, because remember, in 2 years I get to do it all again. So we'll see what happens then.
Yeah. All right. So listen, the newest thing that we're going to start, because I'm a big fan of Kostas Moros on X, what we used to call Twitter. So I see the stuff you're tweeting out there all the time, which is called the craziest shit I read all month. Okay. Because you and I both read a lot of pretty crazy stuff.
Mm-hmm.
I will tell you about the one I found this month, but I want to hear what was the craziest thing that you got to read this past month.
The most fun, maybe crazy. This next month, I'll do a better job of really looking for crazy. But the one that most amused me this week was that Everytown did an amicus brief in Texas about standing. They're in support of a case that's challenging the requirement that a specific sign be placed up if you don't want to allow guns. So the reverse of the vampire rule. You have to post a specific sign saying no guns allowed, and it has to have dimensions and whatever. And Everytown makes all sorts of arguments for why that's not okay.
Why is that not okay?
They want to make it as easy as possible for people to ban guns from their building, and they don't like that it requires a specific sign. And the law also allows, by the way, other consent to be given, or other demands to say no, like someone can tell you no guns, but they make all sorts of arguments for why, well, employees are busy and nobody wants a confrontation. And what I'm getting at, the reason this is all amusing, is they've argued the opposite position when it comes to the vampire rule. They endorsed California's law and Hawaii's law that were, California's law required a specific sign. Hawaii allows businesses to give consent by other means, and they didn't have a problem with any of this. They support it. So they're just taking a diametrically opposed position because they don't like that Texas law says you have to have a specific sign if you want to ban guns, but they're fine with California law saying you have to have a specific sign if you want to allow guns. It's very silly, and that's why Everytown has no principles really,
none whatsoever. But hey, don't let the facts get in the way of a good piece of civilian disarmament legislation. Now, I'll tell you the craziest thing, and I won't get too deep into it, but I found a petition. I was actually going to do a video on it over the weekend, and then I saw it was scheduled for conference on Friday. I was like, this son of a bitch is getting rejected right away. So I'm not going to do a video on it because it's going to get a thumbs down on Monday, which it did, by the way. But it was the matter of DeWild versus the United States, a fascinating legal argument by a pro se defendant who did manage to get his case all the way to a conference before the United States Supreme Court. Pretty awesome. And the issue it says shall not be infringed. So why aren't we entitled to M16 rifles? Pretty good argument.
He's right, but what does he mean entitled? That the government has to give him one?
Well, no, that we actually have we should have access to all of that. And it was a very simple brief. I think you and I probably would have hashed out more legal arguments in it. But yeah, I mean, hey, congratulations to Mr. DeWild. He actually got his case all the way to a conference on the United States, all by his lonesome. All by his lonesome.
Hey, look, Mr. DeWild, if you're watching this, I agree with you. The issue's
hopeless. Yeah, I agree with you too, and God bless you for trying. He and here's the thing: he didn't get convicted of having a machine gun. No, he just filed suit against the United States government because he wanted one, and then he got summary judgmented out. He appealed. 3-judge panel upheld that. He applied for an en banc review of it. That was denied, and then he went. So, Mr. DeWild, if you are out there, bravo, sir. You have some fantastic.
Yeah, you're too early. This Supreme Court's not going to strike down the machine gun ban, but I appreciate the effort.
I do too. All right, our final segment. This is where you get to tell us a little bit about what's going on with Second Amendment Foundation. I know you guys got a lot of pokers and a lot of fires, but a couple of cases that the viewers should be listening up, or things that we might have big dates. What are you doing? That's what we want to hear about. What do you guys got going on?
We have so many cases pending, but this time I'll talk about specific to my work, which is I'm working on 3 different amicus briefs right now. We've got one coming up in Wolford, which I think is going to be very good. We've got one coming up in a Vermont waiting time case because it's a challenge to Vermont's 3-day waiting period to purchase a firearm. And I'm about to, it's going to be amusing because these experts for the state came in and said, back at the founding and thereafter, you couldn't buy a gun right away because, there was limits on production and, you had to wait for it to ship, and muskets took a long time to make. And so what I did is I went onto newspapers.com and pulled up a bunch of ancient newspaper advertisements for guys selling I have 2,500 muskets. Come buy one. Available immediately.
Stop it. BOGO. Buy one, get one free. Come on in.
So this idea, I get it. Yeah, if you lived in some small town or village, maybe it would have been, a bit of a wait or travel to get a gun. But if you lived in a town or city, even in the 1790s or before, I think one of the ads was from 1745, you absolutely could buy a musket or sword or whatever else pretty quickly.
Canon.
There wasn't a wait anyway. So that's going to be a fun one.
In case the neighbors are really driving you nuts. What else you guys got going on?
We have all sorts of, as you said, irons in the fire. We just filed, and the name of the case escapes me right now, but we just filed another cert petition for an AWB case. This one's out of Connecticut. It's also
it's the one that was joined up with Lamont, NAGRV Lamont. That's right,
yeah.
And that's sitting before the United States Supreme Court. And by the way, I got a video coming out tomorrow. There were 2 amicus briefs that came in, one from the Minnesota Gun Owners Caucus and the other one from GOA. And they're both taking on the common use doctrine, and they're coming at it from different ways. They're really freaking good amicus briefs. And you and I both know there's nothing worse than an amicus brief that just says ditto.
Yeah, no, and Rob Dorr wrote that one. It's his first one. We're very proud of it.
It was a good one.
Yeah, and we would have joined. He reached out to me about working on together, and I couldn't because I knew SAF was doing its own brief, so I can't join on it. But it's excellent. I think he worked with my old colleague Anna on it, so I read it. I haven't read the GOA one yet. I will, but
GOA's one. You know what? So here's the thing about the GOA one. This is really interesting, and then we'll cut it loose for the night. But GOA went back and looked at Heller, and Heller went back and, of course, looked at crap going all the way back to Blackstone and stuff like that. And they were talking about where does dangerous and unusual come from. But when you trace the origins of dangerous and unusual, it comes from statutes of Northampton and things like that were restricting the carrying of firearms, not the possession of these types of firearms. So have we been, even guys in our little sphere, are we overblowing dangerous and unusual? Did we overestimate its reach?
Yeah, I mean, it didn't say the Second Amendment doesn't say the right to keep and bear non-dangerous and unusual arms shall not be infringed. It's always been a silly thing, but we just go with it because the Supreme Court's not going to overturn that. Frankly, I'm a realist when it comes to the Supreme Court. But yes, they're right. It only applied to these carry laws. Just so that's a big problem for this whole doctrine.
Well, listen, if it was super easy, then you and I would have to find something else to talk about. But hey, did you have fun again?
Always. It's a good time.
This was fun. This was a lot of fun. We got to do some serious geeking out. Now, listen, real quick before I let everyone go, we will be back again December 8th, unless Kostas has got some office Christmas party to go to or something like that. But Monday, December 8th for Volume 3. In the meantime, all of you guys, enjoy your holiday season. Keep fighting out there and stay safe.